Property leases. Common clauses and what they really mean. Common lease terms and what they mean. Demise.
One thing that's important when agreeing commercial lease is to make sure the tenant has the correct rights to enter into the premises and to operate and to access areas which it requires. If you are going to be let the whole building, then that's less of a problem, but if you're going to be let a part of a building, it's important that the plan shows the extent of your demise and that you check and understand that. It'd be advised to instruct a surveyor to have the area measured, because it's usually your rent is based on the area that you're taking a demise of.
Lease length.
Lease length needs to be negotiated between the landlord and tenant. A short lease is usually anything over 6 months but less than 3 years, and a longer lease is anything beyond that. Anything over 7 years needs to be registered at the land registry, and that will incur additional costs. The longer the lease, that will also increase the stamp duty land tax which is payable.
Break clauses.
Break clauses are important parts of commercial leases and need to be agreed at very early stages between the landlord and the tenant. Break rights are a key term of a commercial lease and give the tenant or the landlord the right to bring the lease to an end early. The one thing that the tenant needs to check are any issues which the landlord looks to incorporate into a break clause that will stop the tenant from exercising its rights, such as notice provisions and/or penalties.
Lease renewals.
Lease renewals need to be considered by the tenant when their contractual term comes to an end. If they've agreed a fixed term lease, then their lease will automatically come to an end at that point. If they have rights under the Landlord Tenant Act 1954, then they will need to speak to a landlord in the early stages to agree a new rent and a new term, or serve a statutory notice. Renewing a lease can take a number of months and depends on the willingness of the parties to agree. It's advisable to try and agree between the parties using surveyors rather than going all the way to court, because that can prove very expensive and timely.
Rent reviews.
Rent reviews give the landlord an opportunity to increase the rent. There are 3 main types of rent reviews. The standard one for office premises is normally an upwards only rent review. Either rent will increase or remain at the existing level but will not decrease. Other rent reviews are turnover rent reviews, i.e. Based on the turnover of a business operating at such areas like food halls, or certain rent reviews can be RPI increased, i.e. the rate of inflation yearly or over a period of time. If the new rent is unaffordable or you don't agree, you can usually refer it to an independent surveyor or an arbitrator. Alternatively, you'll need to go to court, which can take more time and be more costly.
Subletting and assignment.
One area for a business to check is whether they have the rights under their lease to assign or sublet. Under an assignment means that the tenant can pass their lease to another party. It is usual for a landlord to ask for the outgoing tenant to enter into an authorised guarantee agreement, that if the new tenant doesn't pay the rent or comply with the obligations, then they can be asked to go back in and take on those obligations. Under a sublease, the existing tenant will carry on paying the rent to the landlords and have that rent paid by the subtenant.
Insurance.
It is usual for a landlord to insure a building under a commercial lease and for the tenant to pay a proportionate part of the premium. The other issue to check for a tenant is if the building burns down, whether there is a rent suspension clause which enables the tenant not to pay rent whilst the landlord gets planning permission and rebuilds the building, or alternatively, if there is an insured risk where the tenant can't operate their business or get into the building, then they have the right to terminate the lease.
Dilapidations.
Dilapidations means putting the premises back into a good state of repair and condition, which a landlord will need in order to re-let the premises. If the tenant has spent a lot of money, then there needs to be a negotiation between the landlord and tenant on whether the tenant needs to remove all of its fit-out works and what financial arrangement between the parties.
For more information on how to choose the right property for your business, visit the London Growth Hub website.